We all think we know what theft is, right? But do we, really? The law has actually spent centuries building this surprisingly complex architecture around a seemingly simple idea. In this explainer, we're going to deconstruct it, from the classic pickpocket to the modern hacker, and see how the legal system defines the simple act of stealing.
It all really kicks off with a question just like this. I mean, think about it. You can't physically hold a password, so how can it be stolen in the same way a wallet can? This tension, right here, between physical property and digital information is what forces our legal system to constantly evolve. It's the central puzzle we'll be piecing together today. All right, so here's our game plan. We'll start with the absolute building blocks of theft itself. Then, we'll explore crimes of physical taking versus crimes of deception. From there, we'll jump into the wild west of the digital age, and finally, we'll see how the law is trying to simplify this whole mess.
So let's get right to it and start with the foundation. It's pretty wild, but whether we're talking about a stolen car or a stolen database, every single theft crime is built from the exact same two legal components.
And here they are. First, you have the actus reus. That's just some fancy Latin for the guilty act. It's the physical taking of the property. But, and this is absolutely crucial, that alone isn't a crime. You also need the mens rea, the guilty mind. That's the intent to permanently keep it. Think of it this way. Accidentally walking off with someone's identical coat isn't theft, but intentionally taking it is. A prosecutor has to prove both the act and the intent to get a conviction.
Okay, now let's move on to our first major category and see how this foundation applies to crimes where property is physically taken. These are the classic offenses you probably think of when you hear the word theft.
What's really fascinating here is how just one key element changes the entire crime. Larceny, right at the top, is a simple taking without consent, pretty straightforward. But move down to embezzlement, and the key element becomes trust. Think of an accountant who was entrusted with company funds and then helps themselves. And then you've got extortion, where the key element is fear. The property is obtained through threats. See, it's the same outcome, stolen property, but legally they are three very, very different crimes.
But what if the thief doesn't use force or stealth? What if they just lie? Well, that brings us to our second big category, crimes of deception, where theft is accomplished through pure trickery.
A classic example here is the crime of false pretenses, and it illustrates the process perfectly. Step 1, the scammer tells a lie. Step 2, based on that lie, the victim willingly hands over their property. And step 3, the crucial point is, the scammer knew it was a lie all along. It's theft by persuasion, and it's just as illegal as picking a pocket.
This also connects to two other crimes, forgery and uttering. Forgery is the act of creating a fake, like signing someone else's name on a check. Uttering is the act of using it, like trying to cash that forged check at the bank. One is about creation, the other is about presentation. And yeah, if you do both, you've likely committed two separate crimes.
Okay, so we've got our framework for physical property and deception. Now let's see how this all holds up when we move from the physical world right into the digital one.
This is the biggest challenge for modern criminal law. No question. As you can see, the core components, the act and the intent, they're still the same, but the property itself has changed. It's gone from a physical gold bar to, well, a cloud of data. And you can't just lock up a cloud.
This has opened the door to a whole new class of crimes. Now we have identity theft, stealing your personal data, intellectual property theft, stealing a secret formula, and even digital asset theft for things like cryptocurrency or a valuable social media handle. It seems like each new invention creates a new way to steal, and the law is constantly playing catch-up.
So all of this has created a tangled web of different crimes, each with its own specific rules. The next logical step for the legal system was, naturally, to try and untangle it.
It's a fair question, right? When the lines between larceny, embezzlement, and digital fraud get blurry, how can the system even work? The problem was that prosecutors were spending way too much time arguing about which label to use for the crime, instead of focusing on the actual theft.
The answer for many states has been to create consolidated theft statutes. The idea is simple but incredibly powerful. Combine all these different offenses, larceny, embezzlement, false pretenses, into one single crime just called theft. The method used to steal the property, whether by force, trust, or trickery, becomes less important than the core unlawful act.
And this right here is the key takeaway. The goal is to streamline justice. It allows the courts to focus on what truly matters. Did the defendant wrongfully take property with the intent to permanently deprive the owner? It's a practical solution for an increasingly complex world.
So we'll leave you with this thought. We've seen the law evolve from stealing wallets to stealing passwords. But what's next? If an AI creates a valuable piece of art or a groundbreaking algorithm, who owns it? And what does it even mean to steal it? The architecture of theft is always under construction, and it seems the next renovation is just around the corner.